Sai, can you hear me?
Yes, sir, I can.
He is there. Just make him in the main screen. Yeah. So good evening, Sai. Thank you very much for agreeing to interact with our students. And what we have done this time is that we have taken the initiative in the name of Immersion program, so that our students they engage with illustrious alumni, accomplished professionals, and to understand the hands-on experience of the real uh, legal world. So it's really nice to have you for this session. I believe the students are really excited, and also a good number of graduates have joined online. So I also welcome them in this program. I truly believe that interaction with you is going to send across a very good message, and they will be now, after listening to you, doubly motivated to commit to the legal profession and legal education. Without talking much about the initiatives what law school have taken, that I will text you so that you can get to know about it. I invite Murthy, who is the third year student, to give a brief introduction of yours, and then we will be opening up the floor for your interaction, and then followed by question answers. What I have done with the question answer is that we have collated it and merged it theme wise, so that we can save some timing and we can have interactive session a bit longer. So now I ask Murthy to do introduce you to all the students. Murthy.
Thank you, Honorable Dean, sir. Good evening, Sai, sir. Yeah, good evening, students. Before I begin this, let me show a caveat. What follows isn't so much as an introduction, rather it is more. So bear with me as I attempt the latter one. Some blog posts get likes. One blog post got an injunction vacated by the division bench of Honorable Madras High Court in the case of Bajaj Auto versus TVS Motors Limited. That's the kind of advocate and author we have with us for this evening session. Yeah, good evening, everyone. It is my honor to welcome you all to this week's immersion program. We are privileged to have with us our esteemed alumnus and young alumni achiever and senior educate, Shri J. Sai Deepak sir, as our guest of honor. Jay Kumar Sai Deepak Iyer, actually known as JSDR J. Sai Deepak, he was brought up in Hyderabad and completed his undergraduation in Anna University and later enrolled in the LLB program at RGSOPL. He was an alumnus of our first batch, 2006 to 2009. During his stint at IIT, he led a society named Students for India Heritage. And in his second year, along with his classmates, Mr. Nikhil and Mr. Ashwini Balayan, they conducted a moot court titled Verdict. In 2008, he won first prize for his essay, The Elusive Quest for Obviousness, Patent Law's Holy Grail, awarded by the International Association for the Advancement of Teaching and Training in Intellectual Property, making him the second person after late Sri Shamnath Bashir to secure the prize during that time. And the same extended version of this essay was published by the renewed journal Max Planck Institute Review of Intellectual Property Law. And his maiden blog touched on spicy IP titled Sparks Fly as Titans Cross Plugs, and the Bajaj versus TVS dispute was not merely cited by the Honorable Division Bench of Madras Court, but was rallied to vacate the injunction order against TVS. Perhaps it was the first instance of a student's blog being rallied to vacate an injunction, was a testament to his technical acumen and legal depth even as a student. After graduating from high school, Sai Deepak sir joined Sai Krishna and Associates and went on to become an associate partner within 6 years. In 2017, he became independent and established his law chambers of J. Sai Deepak. And during his tenure with Sai Krishna Associates, he led as a lead counsel in cases such as Greenpeace versus Tata Sons and matter concerning the reading of Sentence 79 of the IT Act and the Basmati GI litigation. Post setting up his independent practice in the case of Kerala, famously known as the Sabarimala case, he argues as a counsel for people of Burma on the question of deity rights. And in Supriya Chakrabarti versus Union of India, he represented Bharatiya Sri Shakti, arguing the central thesis of societal rights. It's a masterclass in advocacy. In 2019, he was bestowed with the Young Alumni Achiever Award by the IIT Kharagpur in recognition of his achievements in the legal field. In November 2024, at the age of 39, he was designated as a senior advocate by the Honorable Delhi High Court, becoming one of the youngest to receive this distinction. An eloquent speaker, an intimidating debater, a prolific leader, and someone with deep interest in history, current affairs, and political science. He is also the author of two best-selling books, India That is Bharat and India Bharat Pakistan, part of his ongoing tetralogy. It is truly an honor to welcome you here today. Please join me in welcoming our esteemed guest as we begin this session. Now I request Sai Deepak sir to enlighten us.
First of all, namaste. Thank you for the kind introduction. Am I visible and audible? Am I clear to the audience, please?
Yes, sir.
Yes. Okay, fine. I don't know if this should be in the form of some kind of a pravachan. I don't think it should be a monologue. So why don't we make this interactive so that it's more useful for you than becoming an Atmastuti session for me, where I keep talking about myself. So why don't we start with a couple of questions, and I would only request you to keep the questions relevant to what makes your life meaningful in law school and the legal profession. I'm happy to answer those questions. Let's start with the Q&A if possible, and let's dive into this, and let's make the most of the time that we have.
Yes, sir. We have this first question by Ms. Ilvika or Swati Lakshman Akriti Shukla of second year LLB. The question is...
Sorry, just a second. Who is actually interacting with me? Is this Mr. Murthy?
Yes, sir. I'll be acting as a moderator.
Okay, so your voice is actually slightly muffled. Do you think you can come closer to the mic or see if there's something better you can do? Because I'm having to test it. I'm supposed to hear stuff. Yes.
Yeah, sir. So the question is, how do you approach research and a new case? And how can an young lawyer develop independent legal reasoning, coherent answers, and the ability to frame arguments persuasively without compromising substance?
Two caveats. I'm partially deaf in 1 ear, and second, your voice keeps going in and out, so you'll have to read the question again. And do it slowly. Think of it as a bear act and enunciate slowly.
Yeah. So
Yeah.
that's
Pay attention to the punctuation. That makes modulation better, and it tells the audience what is the emphasis.
yeah. Sai, I will read it out.
Yes, please, please.
So these are the questions which are coming from second year students.
Okay.
It is, how do you approach legal research
Hmm.
and a new case, and how can a young lawyer develop independent legal reasoning, coherent answers, and the ability to frame and communicate arguments persuasively without compromising substance? So basically, I believe they're asking the trade secret of a success in the profession.
I think everybody has their own version of how to go about it. So whatever I share is obviously my personal experience, and it may or may not hold universally true for people across the board. But typically what my approach has been is I've learned from the pearls of wisdom of Dr. Renal Mitra, which is spend 15 minutes on the problem and 5 minutes on the solution. That you have to try and understand the various facets of the problem, distill those questions of law or fact that you can from the problem statement that has been provided to you, so that you're in a position to recraft the problem in a way that you think you can answer. I'm not saying distort the problem, but once a situation is presented to you, because you see, rarely do you come across instances where somebody is asking you for straightforward legal opinions on certain questions of law. What you're going to be presented with is a situation. That situation needs to translate to a legal issue for you. And for you to translate that into a legal issue, you need to start distilling each of those aspects, saying, what is the question of law this poses? Is this a question of law that has an answer? Does this require an application of law? Is there a straightforward factual answer to this question? That's how I would usually start. What is it that you can do from, let's say, a law student perspective? Take the following subjects super seriously. And I don't know if there's a problem with my eyesight, but I see people folding their hands. I don't know how many people are actually taking notes. Or are they actually hoping that they will go back and see a recorded session? Fine, fair, whatever it is. Trust me, I haven't come with a PPT. Therefore, I hope this will be even more engaging and interesting for you. And I think the joke has landed on quite a few people. So, one, take legal research as a subject fairly seriously. Second, as much as law school curriculum does not place enough emphasis on jurisprudence, take it super seriously. 3, fundamental principles of property, therefore Transfer of Property Act, along with Sale of Goods Act, which basically covers all the basket of movable properties by and large. Take these 4 fundamental legislations seriously if you're interested in pursuing a career in civil litigation or civil commercial litigation. Of course, it goes hand in hand with the Specific Relief Act and the Indian Contracts Act. One of the things that has helped me, at least during the course of my preparation in law school, was despite the fact that we were studying law, I hadn't junked or abandoned or jettisoned my engineering training altogether. So sharp questions, which are according to me, are indicative of a sharp mind from an engineering background or a sciences background, largely speaking, is what would distinguish us from people who come from other law schools. That's your strength. Don't abandon that strength. As much as you're expected to become adept at political sciences, humanities, in general law, history, and so on and so forth, what you bring to this table and to this pool of thought is your ability as an engineer to bring laser sharp focus so that nobody can dilute the way you look at it. So that is something that you carry as a soft skill into a problem. Second, mastery over facts before law is super important. When a file is given and you're expected to read the file cover to cover, the test is your ability to close the file and paint a picture in terms of the story as to what does the file represent? What is the narrative that emerges from it? Law baad mein aayega. You focus on the legal aspects later. First question is, what do the facts tell you? So even if you're preparing for moot court propositions, the focus must be on facts primarily. After you've understood the facts, then from there you move to the question of how do I distill the legal proposition that emerges from it. Then you enter the realm of legal research. The mistake that you would make, which is the most predictable mistake, and I think that mistake is compounded by the emergence of AI, is that you'll immediately feed a question to a tool and hope that it vomits an answer. Okay? Don't do that. I know the tendency and the temptation to latch onto AI to make your life easy. I would suggest let it make your life miserable. Let your life be miserable until you're good at something. There's nothing wrong with it. So focus on fundamental legal research, which means don't jump to judgments. Judgments will come later. The first question that you should ask yourself is, which is the statute, which is the provision of the law that applies to this problem? What does the black letter of the law say? Apply your mind to the interpretation of the provision first before you're able to say, perhaps there are certain questions that this provision, let's say, throws up, or it has multiple ambiguities, and therefore I need to look at judgments to answer those ambiguities. Attempt to answer the ambiguities presented by the provision by reference to the statute itself through your own process of analysis, through your own process of reasoning, under the assumption that there is not a single judgment that exists which sheds light on how to interpret the provision. That's the first test. From the facts, when you move to the law, the jump is from the case proposition to the bare act, not to judgments. Once you finish your analysis and you have taken a confident position, applying the principles of interpretation, applying your common sense, because interpretation is not bereft and devoid and divorced of common sense. You apply all of that, and then you see what do judgments say. Imagine the confidence that you get when you realize that you have arrived at the right conclusion, dehorse the judgment once you read the judgment. And second, you will also have developed an independent point of view, which gives you the ability to critique a judgment and say, this judgment has not considered these aspects which are relevant to the issue or which are relevant to the interpretation. And therefore, this judgment is per incurium or it's res integra insofar as certain issues are concerned. So legal research fundamentally calls for two things. One, since it's being applied in the context of a factual matrix, grasp and command and mastery over the factual matrix is condition precedent, followed by understanding the provisions of the law, the legal framework or the statutory framework that applies. Only when you think you don't have answers to certain problems, which the provision throws up, or the application of the provision to the factual matrix throws up, then you can consider judgments. Until then, don't go to judgments, don't go to commentary. I know that this is positively counterintuitive to the suggestions that you get to constantly visit the library to read commentaries. I've never done that. All the books that you see behind me, I haven't read them. I read them on a need to read basis because my primary focus is on the provision and then judgments, because even commentary translates to somebody's opinion on how to read the judgment and their extraction of the ratio depending on their own skills. This becomes a reference only when you know for a fact that perhaps judgments have not answered a question. Let us see what does an authority on a particular subject say in his or her commentary. So there is one anecdote that I'd like to cite, and maybe this helps. It has served me well in law school and out of law school, especially out of law school, which is, I think after the failure of his first major project, Dr. Abdul Kalam was sad and he more or less was in a period of self-imposed exile. And around that time, he was also given the opportunity to host and chaperone Dr. Werner von Braun, the German scientist who was captured by the Americans as part of the war booty between Soviets and Americans. And this man was responsible for the design of the V rockets. And these rockets were devastating Allied forces. And subsequently, the technology behind the V2 rockets became the basis for the space program of NASA. So therefore, Werner von Braun was called the father of the NASA space program. So when the gentleman actually comes to India, and Dr. Kalam has an opportunity to interact with him and spend time with him, and he basically guides him around the place. He notices that Dr. Kalam was in some kind of a pensive mood, and he was constantly lost in thought when he wasn't guiding this man around. So he asked him, what is the problem? What is the issue? So he says, my project failed, and I don't know what to do, and I don't know how to reapproach or revisit the problem. To which this man gives an answer which I think is wonderfully applicable to pursuits of intellectual endeavors, which is our kind of professions. Hard work in this profession is not the number of hours you spend reading, it's the number of hours you spend thinking on the problem. The number of hours you ruminate on the problem to see what are the various angles in which I can approach the situation, and then try and see if there is some kind of a judgment or a precedent to support the angle I wish to approach, I wish to adopt it. Okay. So I'm not asking you to not read. That's not the takeaway. The takeaway is think, read, think. That's the cycle. And if you do that, what this means is your ability to think on your feet when a proposition is thrown at you in the absence of a precedent to support your position is better. Your mind will think better. You'll constantly develop the ability to have answers on the basis of first principles as opposed to answers on the basis of citations. So that's something that I'd certainly suggest as an approach. The rest is, of course, your choice. Next.
Okay, so Sai, there's then again question coming from second year students.
So sorry, I think there's an important call. My sincere apologies. This is unavoidable. Can you give me just 30 seconds? So sorry, just a second. My apologies, please. Yes, sir.
Okay, right. So this is a question coming from second year student Tarun and Elizabeth, that coming from RGSO IPL, how did you transition into litigation, and what is the best roadmap from the first semester through internships, chambers, research, reading, litigation exposure, and advocacy while building a profile and eventually attracting clients, particularly in IP litigation?
I might as well write an Atmakatha in response to this question. But let me try and keep this simple. You don't come from the integrated 5-year program, which means you don't have the luxury of making the same mistakes because you're entering at a different level, at the very least at a graduate level, with a degree to boot under your belt. Considering that, I would only urge and exhort you to take the 3 years that you get extremely seriously. As cliched and as middle-aged as this advice sounds, I would suggest that you take it very, very seriously. I don't know if the good professor has actually had the opportunity to share my reputation and exploits in law school as the troublemaker. So, as the former troublemaker and the last bencher, take my advice or suggestion fairly seriously. Because if you don't sweat in law school, you'll bleed in the profession. And with the advent of AI, the challenges that you will face are higher than the challenges that we faced. Because the prospect of obsolescence, which is you being rendered obsolete at the first stage of the profession itself, are fairly high. So unless and until you bring value to the table when you enter the profession, in terms of originality, diligence, and hard work, this profession will chew you out mercilessly, because this is a jealous and a demanding mistress who 100 choose, but she chooses less than 10. There are enough and more suitors who are in the Swayamvar to marry her. And she will choose, and she is polyamorous in that sense. So she will choose a couple, provided they pass muster on the annuals of hard work, intelligence, and serious application of mind. I'm not expecting, and I certainly don't expect any student to excel in every subject in every semester. Have a plan for yourselves, which means that you ask yourself at some stage during the law school tenure, preferably at least by the 3rd semester, which stream of the profession do you see yourself joining? Transactional practice, litigation practice, advocacy, which specific area do you think you're gravitating towards? Those questions you must have answers to at least by the time you enter the 2nd year. Because the assumption is by the time you enter the 2nd year, you're at least 24 or 25. So here's how I would consider putting forth before you a kind of a roadmap. At least by the time you're 26, you need to know what you should be doing by the time you reach 30. Because once you reach 30, you're no more a new entrant to the profession. You will be seen as someone who knows what they're doing and who knows where they're going, both. Between 30 and 40, you're building on the foundation that you've laid by the time you've done 30, and those 10 years are spent in reaching the mid-tier of the profession. From 40 is where you aspire for the sky. And you say, now sky is the limit, and from here I shoot for everything with this which is possible, because I now have not a Luna, but a 650cc Enfield, to give an Indian example. From there, you can go wherever you wish to. So think of this profession as a mutant or a transformer, which can take the shape that you want it to, which can perform at the level you want it to, provided your intent is to actually use it in that fashion. There is no limit. Sky is truly the limit in this profession. There are any number of doors that this profession can open, from the World Bank to the Supreme Court, anything in between and everything in between and outside of it. So this profession is literally the key that opens the portals of what is possible, and there is no limit to it. That canvas is for you to paint. Provided you have put in the effort, you have done the work, and you take your law school stint seriously, super seriously, for multiple reasons. And since you're my juniors. I take my responsibility towards you even more seriously. So I will be a bit candid and blunt here. There are some stereotypes that are associated with people who pass out of a law school, which is to say that their primary strength is intellectual property. Fortunately, so many of my juniors and batchmates have broken that stereotype. And they've opened the portals to multiple avenues in different areas of practice and different models of practice. I chose intellectual property only because constitutional law wouldn't have paid my bills in New Delhi. Otherwise, I was cut out for constitutional law. I was interested in doing that. So I waited for the day and for that opportune moment when I could start taking up constitutional matters. Plus, commercial litigation prepares you in such a forensic way that it's like mathematics, it sharpens the mind. It forces you to basically cut to the chase and say, come to the point, because nobody has the time for activisty nonsense and nobody has the time for philosophical, let's say, meandering. Even constitutional litigation doesn't function on what people think is you thinking that I will create jurisprudence on my feet. That's not how it works. So the hard-nosed attitude the commercial litigation gives, that skill I transposed and applied it to constitutional law. So I waited for that opportune moment to appear. And in between that, apart from having established myself in IP, I opened the doors for all of the forms of commercial litigation, despite certain barriers, because if you become good at something, that may also be a barrier to an entry into another area of practice, because they stereotype you in that particular area. So I had to break that and get into something else as well. So given these realities, one of the things that you should try and do when you're in law school is create an ecosystem of subjects that you're good at and not reduce yourself to one-trick pony. So assume for a moment that intellectual property interests you. What is it that you can and should do? Apart from intellectual property, you should seriously take up other commercial subjects which are allied, which is competition law is something that you must 100% take up. 2, arbitration is the way of the future significantly, so you'll have to take up arbitration as well. So the ecosystem of subjects that you think you should be good at would be general property fundamentals coupled with intellectual property, coupled with arbitration and competition law. That's the ecosystem that you must try and occupy. Because no client is going to come and say, I will come to you solely for one question. Because if you do practice only one subject, you're saturating your options. And 2, the client will not find you versatile enough. So the industry is moving in a direction where they expect you to be supremely competent in one area, but also be fairly comfortable and knowledgeable in other allied areas, so that you're able to cover 1+++ in some ways. If this has to happen, what is it that you must do in law school, apart from the choice of subjects that you choose to focus on? Kindly take your internships seriously. Between my generation and the incoming interns, if I had to say what is the starkest difference, is the work ethic. It is abysmal, absolutely disappointing. They don't have the ability to sit and work constantly for at least 5 to 6 hours at a stretch, at least 5 to 6 hours, and that's nothing. And that's, I would say, that is fundamentally attributable to the ADHD that social media creates. Because you don't have the ability to even watch something for more than an hour or so if it happens to be boring content or dry content or serious content. So work on these problems that this explosion of technology has created, which is a serious barrier in terms of the skill sets that you are expected to have in the profession. Practice writing extensively for 2 reasons or 3 reasons. 1, writing helps you draft better. It may not always hold true, but it at least gives you the comfort of getting used to the process. 2, writing forces you to sit and do something at a stretch without constantly moving like a monkey from tree to tree. 3, writing forces you to have clarity in terms of what you're saying, because when I speak, I could use the force of my personality and my linguistic skills to try and confound and conflate and confuse. But when you write, and if you say something stupid and idiotic, it'll show. It'll clearly show because it will make sense. So writing is your way of becoming a witness to your own thought process, because then clarity emerges. And that clarity will start showing when you start arguing on fundamental principles, on first principles, on jurisprudence, when you have to think on your feet. So please love writing, fall in love with writing. Otherwise, you will not be able to survive the first 5 years of the profession, because those formative years are going to be spent in drafting in one way or another, either through advocacy or through contracts, whichever way you see it, or opinions. So take writing seriously, take academic writing seriously, take legal writing seriously. I'm not going to give you some nuskha or shortcuts for success. I'm going to tell you what are the skill sets you're expected to have to survive in the industry and do well. 3, as an engineer who's making the transition, or as someone from the sciences who's making the transition to law, your ability to read should be cross-disciplinary. And your ability to connect the dots, pattern recognition, these are strengths that you're expected to have fundamentally as a person from the sciences. And when you bring it to bear on your reading of the law, you should be able to connect multiple things. Therefore, the point I'm trying to make is, if you're looking at beating the competition coming from conventional law schools, draw from your strengths as a science student who's able to recognize patterns, who's able to understand logic better, whose analytical skills are vastly superior, who doesn't have the fear of numbers, and who doesn't suffer from the fear of technology. These are your strengths. If you thought this law school was your escape from technology and engineering, then I'm sorry. The bad news is engineering and law are about to merge fairly quickly in the profession itself. So there is no way you can run away from it. Econometrics, economics, computation, statistics, and technology are going to become standard expectations of most lawyers of the future or even the present. These are the expectations from clients. So never suffer from the fear or phobia of any subject. You should be able to digest pig iron. That should be the fundamental test of people who pass out from this law school. These are the skill sets. So every internship is either a process of selection or elimination of what is it that you ultimately wish to do at the end of 6 semesters. So take your internships strategically, seriously, pay attention. Show up, make sure that you're the one who's taking initiative in your internships to ask for work. At this stage, do not expect any kind of stipends or rewards. The profession is changing, so let them do that. But your job is to make sure that you're there and you can be counted as a person who's a stand-in associate despite being an intern. That is the way you operate, because compared to the 18-year-olds and the 20-year-olds who are entering the profession from five-year law schools, you are entering at the age of 23 and 25. So greater sense of responsibility and maturity is expected of you. Please take this seriously. As boring, as dreary as it sounds, this is what you should be considering seriously. Otherwise, the tsunami of AI that's going to come, I don't know what it's going to do to the profession. I'm not trying to paint a bleak picture. I'm just saying we don't know, and uncertainty is always bad. So the only way to beat uncertainty is to prepare to the best of your abilities. You're in the trenches. You're not out in the battlefield. Use this to simulate the battlefield. Ask yourself, how do I make myself useful to the associate I'm assigned to and I'm supposed to report to during my internships? How do I become their associate? How do I make sure that they can rely on me for the reading of a file, for the analysis of a file, for research, for carrying around files, for knowing page numbers, for tabulating stuff, for making stuff easy for a senior to read because they have multiple files to read. You don't have as many files to read. These are things that you must focus on in internships. One thing, your ego should be thrown in the dustbin before you enter the profession. Because if you don't, the profession has a wonderful way of shattering your ego and showing your awqad. I'm telling you this bluntly. It will beautifully tell you where you stand and it will cut you to size ruthlessly without an emotion spent, and it has no time for your tears or for your hurt sentiments. So when you enter the profession, drop the ego. Learn first. Earn the right to have an ego before you strike a distinction between confidence and ego. I'm not asking you to be different, but ego is a different threshold altogether. Nothing and no work is beneath you should be the first option. There will come a point where you get to choose and say no. Until that point, everything that comes your way, you must do. Next.
I'll be taking leave. I have a meeting to attend. So
Sure,
now,
sir.
I'll try to join if it continues, after
No, please. I'll get to talk to students about faculty behind your back. So please carry on.
Yeah, but it's going online YouTube also, so no problem. Okay, thank you. So now Murthy will continue from here.
Sure,
I'll try
sure.
to join back once meeting is over. Thank you.
No problem. Sure. Thank you so much. Thanks for organizing this.
Yes, sir, the next question is,
Yeah.
how important is choosing the right senior or chamber or a litigation environment for a long-term career? For someone interested in constitutional law, commercial or IP litigation, should a fresher join a senior advocate's chamber or a law firm dispute resolution practice? And should someone specialize earlier first build broad litigation experience?
Joining a senior advocate's chamber at the beginning of your profession, in my view, is a disastrous decision. It's a blunder for multiple reasons. Every professional relationship functions on what can you get and what can you give. As a fresher, you're practically useless to a senior advocate. You're useless to a senior advocate because the speed at which the senior advocate would want to go and the kind of skills that the senior advocate can take for granted from people with experience, and which is what they should be in terms of reading of the files, marking of the files, asking questions which the briefing counsel is not telling you, playing the red team to the blue team of the solicitor's team, so that the solicitor, if he is misleading you on a particular point of law or he has not told you something, it's for your briefing, it's for your own team to read up the file and say, sir, he's not shown you this, and this is important. This is a problematic aspect of the case. This is the chink in the armor. This is where I think we'll be pressed by the bench for answers. A fresher is in no position to do it. By and large, I'm applying the average rule, the median rule. Similarly, from the perspective of the learner, you are expected to develop your drafting skills, your research skills, your client counseling skills, your strategic skills, your ability to put a case together, your ability to brief people, your ability to brief your own senior. You're not going to learn that in a senior advocate's office because most senior advocates, unless they're circumventing the rules, don't draft their file. They're not expected to. They're not supposed to under the law. So if you think I'll go there because I'll have a fantastic name in my CV, maybe, but at the end of the day, it's not going to translate to real acquisition of skills at all. So if you're serious about acquiring skill sets and investing sufficiently in your formative years in terms of learning curve, which is to learn how to draft, which is to learn how to draft both legal, the pleadings from the opinions to whatnot, joining a senior's office is useless even to you. I don't see how that helps. Unless and until you're hoping that joining a senior's chamber who is reputed is going to increase your chances in the matrimonial market, other than that, it has no consequence. In the profession, nobody's going to take you seriously. If somebody takes you seriously matrimonially, I think you're also cheating them because you're a nobody in the profession. So if you want to take your learning curve seriously, I think I've mentioned this somewhere, the 7-year principle, by and large, you can even make it the 8-year principle, but the first 3 years must be spent in rigorous drafting, rigorous assistance. Those who can't assist cannot lead, period. Those who don't know how to brief cannot be briefed because they don't know how to brief. And the essence of your experience in the legal profession when it comes to advocacy after a certain point is the speed with which you choose the top 5 bullets out of the 25 bullets and present it in the 5 minutes that you get, so that you present the essence of a case at the Supreme Court stage after the entire journey it has traversed from the trial court to the first appellate court and whatnot, and then reaches the Supreme Court. You bring it down to 1 or 2 questions. You're being paid for your ability to understand the case and bring out the best possible points that will catch the attention of the judge in 30 seconds so that you live to fight another day. That calls for a lot of experience. That calls for a lot of hard work. Spending hundreds of hours doing this. So joining a chamber of a senior advocate in the formative years, I wouldn't recommend it. Of course, there are exceptions to this rule where somebody has managed to use their internships so well and honed their skills so well, and they've maintained a working relationship with someone during the course of their law school that they're constantly drafting, researching for them, that they're ready to join a seniors team. But even then, I wouldn't say it's much, because drafting and finishing research in real-time litigation for 3 years, doing that at least for 12 to 14 hours a day for 3 years is different from doing this part-time in law school or during internships. There is no comparison whatsoever. You've not seen the stakes, you've not felt the pressure, you've not had a soul-shattering experience where you've made a horrible mistake, and then you've had to dust yourself up, pick yourself up, and start working. Those are things which are necessary rites of passage. be told that you've completely screwed up on a subject or a matter, and to know what it is to make a mistake. If you've not done any of that, your mental strength is not building to withstand the pressure as you go high. And mental strength is built by handling the pressure. It's not by not making mistakes. Of course, that will be your endeavor, but you are bound to make mistakes. To be able to assess the mistake, do a post-mortem analysis of the mistake and understand, where did I go wrong? Why did I go wrong? At this stage of my career, can I make this mistake? Is this a judgment error, or is this an error of diligence? Was I plain and simple stupid? These are questions you should ask yourself. You might think, does every lawyer put himself through this kind of a rigor to reach a certain place in the profession? Allow me to say this, you don't know what people go through behind the scenes. You have no idea what they're going through behind the scenes. The best of the people that I know in the profession are built in this mold. I am no exception. So if you want to be an also-ran, you can do much lesser than this and still survive. So I am not here to give you suggestions on how to be an also-ran in the profession. If that's the case, you should count me out of the session. I'm trying to tell you what is it that you can do to reach a pinnacle, or let's say a position of prominence where you're known for your competence. If that's your goal, that's your benchmark, that's your vision, then this is the way. Otherwise, there are people who survive. You want to survive, you can do that without doing any of this.
Thank you, sir. Sir, the next question is by Ms. Ritu Tiwari and Mr. Suhail. What major changes have you witnessed in IP practice? What skills have become
I have questions
non-negotiable?
on the IP center. Give me some non-IP questions. I've done so much beyond IP, and I've done
The next question is
lot of
writing. Beyond traditional IP practice, what emerging are niche areas, particularly commercial, corporate, technology, data protection, and telecommunications, offer strong long-term opportunities? And how should students decide where to specialize?
I can't tell you where to specialize, and that's a question that is best not put to anyone else. That's a decision you should take for yourself. Nobody should be telling you what you should be specializing in. That should be a function of the decision that you take post your own reading of the situation, your aptitude for a particular subject, and the opportunity you sense in it, and your internships. So I would recommend that you don't ask anyone, what should I specialize in? That's an extremely personal, individual choice, which is based on some data that you collect of your own track record. So don't ask anyone that question, is my humble suggestion. If you're looking at some subjects where there is a paucity of talent, frankly, at this point, where I stand, there is no paucity of people and talent on any subject, whether it's sports law, medical law, negligence law, space law, whatever law. I don't see any dearth of options here at all. So if you think you'll be the first to start something at this point with so many startup ventures in multiple subjects, that may not be the case. So what you can certainly focus on is some of these areas still don't have a crystallized legal framework or an established patina of judgments or case law. So there's a lot of opportunity to contribute to the growth of jurisprudence in specific subjects. So interface between AI and law is one such area. There's a lot of scope even in IP, but if you ask me, the unorthodox combination that people are not considering and they should be looking at is they should read IP, IBC, and Companies Act together. I would suggest that you start doing it, because there will come a point where IP is just treated as just another commercial asset, and it will have to function within the larger context of Companies Act. And therefore, every company has to consider the prospect of an IBC litigation at some stage or IBC compliance at some stage. So that's a universe that you must seriously consider. During my days in law school, intellectual property and Companies Act were seen as far apart, mentally speaking, as India and Pakistan. But today, that's not the case. They're all connected. Commercial reality has connected most of those subjects which people thought would have never been interlinkable or interoperable. So that's perhaps why at the beginning of the session I said cross-disciplinary reading and the ability to recognize patterns is important. So when you choose a particular subject, choose an allied area and an ecosystem of subjects. I'm preempting all questions of this nature by asking you to focus on creating an ecosystem of subjects. There is no way that you can consider becoming an arbitration expert unless and until you're looking at um, the Contracts Act, you're looking at the Arbitration Act, you're looking at multiple provisions of the IBC, because those things interplay. And you're also focusing on hyper specialist areas of arbitration such as energy sector, construction sector, whatever. But that is an understanding of the industry coupled with the legal framework. And you'll still have to come back to the legal framework as it stands. So choose certain subjects which work together. In fact, in your internships, one of the things that you should see is when a particular case of arbitration or an IPC case or an IP matter comes about, does it limit itself only to that particular statute or that area? You will see 9 out of 10 times that's not the case. You'll be forced to read up multiple subjects. Because when two parties fight, they are not fighting saying, I will now fight you on trademarks, I will now fight you on IBC. For them, it is a broad business fight. And therefore, their intention will be to open multiple fronts against each other. IBC litigation, company litigation for operational mismanagement before the NCLT under 241, 242. And you're also looking at IP litigation at some point. And if competition law applies, that is also possible. So if two biggies are fighting against each other, they are going to open as many baskets and as many fronts of battles as possible, in which case the scope of the fight is not going to be limited to 1 or 2 specialist subjects. Then imagine, do you want to be people who want to take up only one of those fights, or do you want to be good enough to handle the entire basket of litigation end to end? That's the question you should be asking yourself, which is how versatile and how broad should my knowledge base be in order for me to handle a broad spectrum of litigation? Anybody who practices tech plus IP law today, especially on the high-tech front when it comes to standard essential patents or pharmaceutical drugs, cannot ignore the regulatory framework as it exists, cannot ignore the framework of competition law as it exists. So if you want to be good at pharmaceutical IP litigation or pharmaceutical patent litigation, you will 100% have to know how the Drugs and Cosmetics Act works. And you can't limit yourself only to the knowledge of the subject as it exists in India. You'll have to talk about America, you'll have to talk about Canada, you'll have to talk about European Union, Japan, all the major countries which have advanced forms of pharmaceutical patent litigation. So I hope that answers the question. Filter out those questions which are on similar lines. Go for deeper questions.
Yes, sir. Sir, the next question is, if you are starting law school or your legal career again today, what would you do differently? What lessons, decisions, or habits contributed most to your success? And how did you deal with periods of uncertainty, setbacks, or self-doubt?
I would have considered taking up economics as a subject if it's available within law school or within the IIT ecosystem as one of my electives and gone deeper into the subject. I would certainly take up artificial intelligence as one of my electives. In fact, I don't know if people know this. They have no reason to know, of course. I took up gas dynamics and space propulsion from the mechanical engineering department as one of my electives in law school in IIT Kharagpur. Just for the heck of it, because I didn't want to lose touch with my engineering background. That's the only reason I did it. And since you're part of the IIT ecosystem and you get to choose from a huge basket of electives, don't let go of that opportunity if you can add value to your legal knowledge by taking up subjects from the humanities departments which add value to this. If economics is available, I would recommend you to take it up. If statistics as a subject is available, which it is, please take it up. I know for a fact that one particular professor who used to teach statistics to MTech students and BTech students was also brought on board to teach us as part of law school. I don't know if that's still part of the curriculum, but that's an extremely important. So economics and statistics, I would 100% make it part of law school. Second thing I would perhaps do is watch DC++ a little bit less. And I don't know if that's still a thing there. So I would consider focusing on attaching myself to a law firm in Calcutta, where I give them my services during the tenure of my law school, because that's the practice in quite a few places. So for instance, if you were studying in GLC Mumbai or ILS Pune, where I think law school is barely about 5 or 6 hours, most of the students associate themselves with law firms in those cities so that they spend their evening hours or morning hours, depending on the timings of the law school, working in those places. because law is fundamentally a vocational profession. So if you do that, you will hit the profession running. You will hit the ground running in a much better way, as opposed to trying to keep pace with the profession and play catch up after joining the profession. And considering that virtual working has become a norm post-COVID, the distance between Kharagpur and Calcutta or Kolkata shouldn't make a difference anymore. And I'm positive that if you do well in internships and you choose to be associated with a law firm and you tell them, I'm available for these services, please let me know, I think you should take up that option. 3 is all the avenues for public speaking and the ability to articulate yourself, which are available within the IIT ecosystem as part of your festivals or whatever, take them up. Please do take them up. At some point, your knowledge of the subject and your ability to understand an audience, there has to be a marriage between these 2 skills. Because contrary to other professions where perhaps you're dealing with machines, let's say in the hardcore engineering profession, here you're dealing with people in a very, very real way. So your ability to read people, your ability to read the audience, your ability to read the room, and your ability to play with words, emphasis, modulation, sarcasm, satire, irony, these are very different tools altogether, and which are the softer tools of advocacy, which are the softer tools of the legal profession. So try and spend a lot of time reading history, political science, and a variety of subjects that give you the ocean of human experience to draw from, because you can't experience everything in your lifetime. History and books help you prepare a reservoir of vicarious experience where you're drawing from the experience of others. It could just be a fantastic joke that you crack in court, citing an anecdote which changes the atmosphere of the court within 30 seconds, and the hostile audience could be smiling. You never know. So if you're serious about advocacy skills or even impressing a client, let's say you're actually stuck in an elevator and there's a power shutdown, and you're stuck in an elevator with a client or a potential client or someone you don't know, and you're stuck there for maybe 30 minutes or 40 minutes or whatever. There's a decent chance that if you manage to strike up a good conversation, an interesting conversation, you might actually make a client out of the person who's there in the elevator. It has happened hundreds of times for me on a flight. Let me let you in on a particular secret. People who travel in business class don't do so just because it's more comfortable. They travel there because it's also a fantastic networking opportunity, because the person sitting next to you could be important, and therefore you could strike up a conversation, and who knows where that could go. It's always possible. So your ability to network. And also from my law school, so I can take some liberties here. The impression and the perception that people from the sciences are inarticulate, don't know how to speak clearly, even in their native tongues, or to string a sentence in a sophisticated fashion, that perception needs to die. And the best way is when this law school and its alumni become examples of articulate products of an institution who come from the sciences background. I am not saying language is the be all and end all. Language is like the icing. Agar cake nahi hai, to kahe ka icing? It doesn't make sense at all. There is no point of having a side dish when the main dish is missing. So the main dish is the content. It's the subject. It's the subject matter expertise. Articulation is the icing part of it. You could be articulate in writing. You could be average in spoken advocacy. That's perfectly fine. Everyone has a place in the profession depending on their skills and strengths. I've seen brilliant people who are amazing at strategy and who choose to become filing counsels, solicitors, running fantastic law firms, solo practices. And senior advocates pick up so much of knowledge and so much of strategic skills from the people who brief them. It's a learning experience sometimes to be instructed and briefed by a person who knows the file and the subject inside out. It's an amazing experience because they're giving you the gist of their experience in the course of 1 hour. And if you pick that up, you've understood a new subject, you've got an insight into it, and you're ready for another area of practice. So a mind that is willing to consume knowledge left, right, and center like sponge, like dry sponge, is the best skill set that you can have if you wish to beat people in the profession, do really well in the profession. You are housed in an institution such as Harvard, in the sense that it's a full-fledged university with a variety of subjects to offer. So flex it properly, use it properly, and make sure that your choice of electives represents a combination which is the way of the future. There's a reason why this law school was set up in a technical institution, so that you have law and technology, and since it has a humanities department as well, the best of humanities courses coming to make you the best possible product. NLS Bangalore does not have your advantage. None of the national law schools have your advantage. You have the unique advantage. So when you choose your electives, please try and look at the entire IT ecosystem as opposed to just the law school electives. That would be my suggestion. Next.
Sir, now we'll start taking the questions directly from the audience.
Yeah. Give me some sample introduction in terms of which year or what do you do, so that I understand. Keep the question specific and keep it pointed so that you extract the most out of me. If you make it blanket and vague and general, you'll get vague BS, and I don't think you've signed up for that.
Sir, am I audible?
Yes, please. You're audible and visible. Sarthak, go on.
Yes. Sir, I am Sarthak Pandya. I am alum of RG. And sir, my question to you is that on your each and every word, I can relate to it. And sir, the question is, you have become a senior advocate at very young age.
Okay.
So, sir, if I want to be a senior advocate, leaving aside all the politics and everything, what are the steps for me, sir?
आप पॉलिटिक्स को छोड़ ही नहीं सकते अगर आपको सीनियर एडवोकेट बनना है.
जी sir.
What you have to understand is, understanding and navigating the system is also knowledge. क्योंकि एक academy examination तो है नहीं. एक बार
Absolutely,
advocacy करी तो काहे का academics? Now it is the real world. You are dealing with people, you're dealing with jugaad, you're dealing with existing networks, you're dealing with lobbies, you're dealing with factions, you're dealing with all sorts of considerations, religion, caste, region, whatnot. This is India, for God's sakes. So do you expect them to not feature anywhere in the profession? 100% they would. On a daily basis, when you're trying to make a point, there's a decent chance that in quite a few parts of this country, who you are, where you come from, what your color is, what language you speak, all of this makes a difference to the quality of reception that you get. So don't discount it fully, but I understand where your question is coming from. So let me split it into two parts. There have been people who have been designated at a much younger age. I believe Mr. Gopal Subramanian was designated at the age of 37. Dr. Singhvi also perhaps at the age of 37. Mr. Chetan Sharma, who is the current ASG of the Delhi High Court, was designated at the age of 38. Mr. Akhil Sibal was designated, I think, about 37, 38. So I don't want to highlight my age of designation beyond a point, because there are others who have done it. I had a goal in my head that I would want it before 40. That I was very clear about it, because that was a benchmark in my head. And if the results of the Delhi High Court designation process of 2024 had come out earlier, I'd have been designated at the age of 38 itself, because the process started in March 2024 when I was still 38, and the process ended a week after my birthday. Otherwise, if it had happened a week before, it would have happened at the age of 38. Okay, so maybe I approached this entire thing like an engineer, saying I want this before this age. Okay. And therefore, there was some degree of construction of a vision, and there was a lot of luck also. Okay, because तैयारी आपके हाथ में है, लेकिन वो opportunity या अवकाश आपके टेबल पे आके गिरेगा, ये तो विधि है ना, that is नियति. That you don't know, you can't guarantee that. And the question is, when that opportunity comes, can you recognize the magnitude of the opportunity and really make the most of it? So the first thing that I would say is, आपके हाथ में जो भी है, which is in terms of preparation, your ability to make sure that every day when you go to court, you take it seriously, because it's like a blood sport. आप अच्छा करेंगे तो 1000 लोग सुनेंगे, आप बुरा करेंगे तो 10,000 लोग सुनेंगे. So if you don't perform well in court, that news will spread faster. And the higher you grow and the faster you grow, your bad performances will travel faster than your good performances. Because they'll be like, oh, he did it like this. Oh, he got beaten in court like this because he didn't come prepared, or he was not ready with an answer to a particular question. And take it from me, everybody has 1 or 2 bad days on a regular basis, simply because it's a function of the number of matters you take. It's a function of whether you've been briefed properly. You'll have to account for all of that. But what can you do? You pay conscious attention to your journey and make sure that you are not seen wavering in your focus. Okay. This profession, put it in the legendary words of the immortal Ram Jethmalani, rewards industry, industry, and industry. And by industry, he used it as a synonym for hard work. Okay. And it rewards hard work exponentially in the form of a geometric progression. Okay. So that's one, which means if you pity yourself for working hard, I don't know what to say. If I say something, then I'll get the same reactions that Narayana Murthy got for his 80-hour work comment. Okay. But the genuine reality is, work-life balance पहले नहीं होता है, उसको बनाना पड़ता है बाद में. Okay. If you ask for work-life balance at the beginning, I'm not saying it's bad. Maybe that's how the next generation sees it. I'm saying you're not improving your ability to work longer. It's like an athlete saying, I want a work-life balance when I'm preparing for Olympics. I don't see how that works. If you want to be Neeraj Chopra and you want to beat Arshad Nadeem and you want to cross the 90-meter barrier, knowing fully well that Arshad Nadeem has the height, he has the build, and he has already hit 90 meters and he's bound to get better next year, then आप balance को चुनेंगे या फिर आप जुनून चुनेंगे? That's what you have to ask yourself, right? So I don't know what to say there. All I can say is it is politically incorrect, but nevertheless I'll say it because I'm known to saying politically incorrect things, that the first 5 years, if you're serious about the profession, please forget everything else. Health is important. Health is certainly important. Okay. But other distractions will need to take a backseat. That is my suggestion, and I've applied it. I've reaped the results and the rewards. You don't want it, don't do it. Choice is yours. Okay. Then you will also realize after a point that talent की एक सीमा होती है in terms of glass ceiling, because उस stage के बाद talent का कोई काम नहीं है. उसके बाद दूसरे तरह का दिमाग लगता है, which is इस situation में लोगों के साथ कैसे deal किया जाता है. Okay. There it is not academic knowledge anymore. It's your skill set as a student of psychology that comes into play, both individual psychology and mass psychology. And so, as someone who's been through the process, allow me to say this: talent alone isn't enough to be designated. Talent is necessary, but not sufficient, to put it in the language of an engineer or a student of mathematics. After that, what is necessary is to see, okay, ये system कैसे काम करता है. Okay. Client is not going to come to you just because you're wonderful at the subject. They are going to come to you also because you know how the system works. कौन कैसे सोचता है? Because you're not engaging with an inanimate system, you're engaging with a system where a human is at the center of the system. So to be able to read people, to be able to understand the situation, कहाँ पे क्या बोलना है और कहाँ पे मुंह बंद रखना है, that is an important skill set. They constantly say that discretion is the better part of advocacy, which basically means keep your mouth shut when you don't need to open it. That's the impolite way of putting it. Okay, that is important. So what is it that other law schools have which I don't find, or at least I don't want to say I don't want to find, I don't find because I haven't interacted with you. I don't want to make a general statement. Engineers in general don't have, or I haven't seen them rank high on articulation and soft skills in terms of understanding and navigating systems, dealing with people. See, you have to realize when you go from this law school, they already think ये engineer babu or this girl यहाँ पे क्या कर रहे हैं, ये यहाँ पे कैसे टपक पड़े is the basic question they'll be asking. And they will continue to ask this question as long as it says School of Intellectual Property Law. Okay? Because they think you're from the engineering background, you're carrying the very same set of skills. So if that barrier has to be broken, then you have an additional barrier to meet compared to other law students or other law graduates on this front. So when you're doing your internships, apart from spending time on the subject, law firm का atmosphere कैसे होता है, चेम्बर के ट्रेडिशंस क्या होते हैं, यहाँ पे हायरार्की कैसे काम करती है, कोर्ट के अंदर how do you go? Somebody wants to grow a funk and go inside the court, the profession will stop taking you seriously, period. इस प्रोफेशन के कुछ मापदंड हैं, उसके अंदर आपको काम करना है तो कीजिए, वरना कोई आपको सीरियसली लेगा नहीं. Then you can become a stand-up comedian and comment on the system after having failed in the system. You can do that. I've seen quite a few lawyers who've not succeeded in the system, and then they decide that the only way that they can get back at the system is to become a stand-up comedian to comment about the system, क्योंकि उनकी दाल जो है यहाँ पे गली नहीं, period. So, if you want the profession to take you seriously, understand that this is a profession that has its own set of rules. You want to break the rule, this is not the place. You want to break the rule, do it in a slightly different way after you have actually reached a certain position. Also, please do consider the fact that whether you like it or not, the world is not horizontal, it is vertical in several ways. After all, you're appearing before a judge. So the position is not equal, the position is vertical. So knowing how to present, knowing where to calm down, knowing where to listen, knowing how to take a hint, these are aspects that you gradually pick up as part of advocacy. So most of the time, after having read the file, at least 60% of the energy is being spent on understanding the situation and the person more than anything else. Because by that time, you're expected to by default know the file and the subject. That is taken for granted. What happens after that is where the extra factor or the zinc factor lies, which is how do I know how to handle this particular audience, how to present this audience and bring it to my point of view. Next.
My question is that.
Thank you very much, sir.
Hello, Sai, I'm very here. My question is, how important is trial advocacy in the context of litigation? And the popular opinion is people usually starting up with high courts and Supreme Court. On the contrary, trial courts, as per my experience, has been very enlightening for me. And as a person who's seriously looking forward to litigation, how can I better hone skills that can help me in trial court litigation and the subsequent process?
First of all, I think you've answered the first part of your question, which is trial advocacy is the most important. Second, not all high courts are high courts. The original side of a high court is a district court and therefore a trial court for all practical purposes. Because the high court has three sides. You have the appellate side, you have the writ side, and you have the original side. So the writ side is the actual high court plenary side, and the appellate side is the high court side, according to CPC, depending on where you're starting from. But the original side is a district court. It is treated as a trial court because that's the court of first instance. So that one assumption in your question, I'd like to dislodge and push back. But I agree with the broad principle that you're making. I agree with it 100%. I would never recommend anybody directly jumping into appellate practice or the Supreme Court practice without knowing how it is to build a case and conduct a case in trial court. I would agree with you. But to answer the second part of your question, what is it that I must do? Is your question from a civil side or a criminal side? Specify that and then I'll answer the question.
My question is from the side.
Sorry, from?
Side. Criminal.
Criminal. I should plead ignorance because I haven't practiced criminal trials. I can only say that I know that the strength of a criminal lawyer is his trial practice, especially their ability to understand Evidence Act and apply it beautifully well. I can do a limited compare and contrast exercise for you. If you're a civil lawyer, evidence, CPC, drafting. If you're a criminal lawyer, CRPC and evidence, not too much of drafting, because उसमें ज़्यादा drafting तो होता नहीं है. I'm not saying drafting has no value, but not to the same extent as civil litigation. So whether it's civil or criminal side, I can positively say with a certain degree of confidence and responsibility that there is no substitute for trial court experience. And the way you're able to see that entire journey right into the Supreme Court, even after becoming an appellate lawyer or a Supreme Court lawyer, you realize that your trial experience holds you in fantastic stead. It gives you an insight into the system. It tells you how much of importance you must give to procedure, how much of importance you must give to the Evidence Act. These are things which are invaluable. There is no substitute for this at all. I didn't start my practice on the non-trial side. I started it on the original side of the High Court, the commercial side of the High Court. Therefore, it was trial court for all practical purposes. And I've appeared in the city civil courts of Bangalore. I've appeared in Tisasari. I've appeared in Patiala House. I've appeared in Saket. I have appeared in CBI special courts in Tisasari. I've taken up matters across the board on the trial side as well. I've appeared in city civil courts in Chennai. I've gone to Hyderabad city civil courts as well. And getting used to the atmosphere, to be able to make an argument in those courts as well, where you sometimes think, will they understand this? Will they not understand this? Well, it's your job to explain. The audience is there, and it's an audience you can't change. So your option is either keep seeking adjournments or make a case out, make it simple for the person to understand. Try explaining pharmaceutical litigation to someone in the city civil court, and I would say you'd have done a fantastic job if you come out having explained a good point of the facts. Not because there is a problem with pedigree or quality, but if a forum is not used to a certain kind of litigation, you can't blame the forum for being new to it. So when we've gone to those courts to explain important matters of the pharmaceutical side, IP side, or even non-IP side, hardcore white-collar offenses, the test of advocacy is stop blaming the audience and find a way to convey and communicate with the audience. Otherwise, it's a simple case of what's the saying? Naach na jaane aangan teda. You don't know how to dance, and therefore you're saying the floor is uneven. That's not going to change the fact that you don't know how to perform. Next.
Thank you, sir.
Hello. Namaskaram, sir. I am Asutosh Penjan from final year LLB student. Sir, my question is how to work on different cases where in one case we are appearing as a appellant, but in similar infringement matter we are in another case we are appearing for respondent. So how is your approach in both cases?
I'm so sorry. I didn't understand the question. Can you rephrase it for me? Perhaps I wasn't paying attention. Can you please
I am asking in an infringement suit of IP, let's say. So
Right.
How is your approach while appearing for an appellant or in the similar kind of matter when you are appearing for the respondent?
I think it's too broad a question. I'll try and answer it to the best of my abilities. See, whether you appear for an appellant or a respondent, at least after the first 5 or 6 years of being in the profession, your mind is fairly flexible and malleable to argue on both sides, because एक particular case में आप किस तरफ से appear होंगे ये आप decide नहीं कर सकते हैं, because it depends on the opportunity that comes your way. So, which is why sometimes I say that the fact that you end on the winning side is largely a function of who gets the better case in terms of merits. And of course, the additional factor is who makes a better case despite having inherited a bad case. Because at the end of the day, it's not the inherent merits of the case, but it's the strength that you manage to portray to the court. It is a matter of narratives. It is a matter of setting that story. So I'm less concerned about who I appear for. I'm more concerned about keeping my mind open to both points of view. Because even if I prepare for one side, I have to anticipate, preempt, and respond to the questions of the other side or to the arguments of the other side. So as part of my preparation, it's not just about knowing my case, it's also about knowing what is it that they're going to present, how are they going to present their case, and anticipating it. So as part of your, this is what in Hindu philosophy we call it Purva Paksha, which is you accept the other side's argument and their position, and then you prove why they are wrong. which is when you're trying to destroy an argument from the other side, you inhabit the argument, step into the shoes of the other side, and then say, "Aap galat isiliye ho." You have to come to that conclusion. And that's the old Mimamsa school of argumentation, where you inhabit the argument before you reject the validity. So, one, keep an open mind, because you never know which side you're supposed to argue from. So don't suffer from the, let's say, the stereotypes that criminal counsel suffer from sometimes, which is you've been a prosecutor's counsel all your life, or you've been a defense counsel all your life, which makes it difficult for you to move on the other side. But even there, I don't think beyond someone who chooses to be a government counsel for a long time, private practitioners get to appear on both sides. So as a private practitioner, whether it's on the civil side or the criminal side, on the appellate side or the trial side, the idea is your mind needs to be like water. It needs to be able to move in different directions. So don't be stuck up on whether you're appearing on this side or that side. It doesn't make a difference at all. Next. 10 more minutes. We'll wrap this up at 7:30 hard stop, because after that I have my briefings. Yes, please.
Good evening, Mr. Sai. I'm Surya from Bangalore. First, I'd like to set brief context. I am a student of anthropology and economics, and I've also done engineering. I encountered your, section on decolonial scholarship, where you've referred to indigenous societies and their reconstruction in South America. So I love the fact that you mentioned that we shouldn't be a one-trick pony, which is something that's associated with Rajiv Gandhi School of IP Law, because we are engineers, and most of us, most of the people in the market perceive us as IP specialists. My question to you is, as a fellow writer and who aspires to be a lawyer come historian, sociologist, what sort of a writing regimen would you recommend me to follow? Because in terms of energy management, it's quite draining. Law school, contrary to my earlier belief, has become intense. So would you recommend a particular writing regimen that you followed, or the one that you still follow right now, because you're still writing on your third part to your book? That would be my
If law school is draining you, I don't know what the profession will do to you. All I can say is, despite so when I wrote the first two books, it's not as if I was sitting jobless. In fact, in COVID, I was appearing across the country virtually. And the only thing that I was able to save was the travel time to court, which is about 45 minutes, door to door, 19 kilometers, so about 1.5 hours, that's it. But other than that, everything else remained the same. And the writing regimen was about 16,000 to 20,000 words a month. If you ask me how I wrote those books, and I'll also tell you how I'm planning to finish the third book, I told myself I need a book of approximately 1 lakh words. 1 lakh words translates to anywhere between 250 to 300 words per page if you go by the standard book size. And therefore, I was looking at a book of anywhere between 450 to 500 pages. I practically applied operations research in terms of how I crafted the book. And I gave every chapter a certain deadline, and I gave every chapter an extension window of 15 days. So 16,000 to 20,000 words and an extension of 15 days. The first book, which is a smaller book of approximately 1,20,000, 40,000 words, was finished in 6 months, 15 days. And the second book was finished in 6 months and 21 days, back to back in 2 years. And even if I say so myself, both of them are as good as PhD doctoral thesis in terms of what I've written. The third book has taken a lot of time, primarily because of explosion of practice commitments and other commitments as well. I consciously didn't write the third book in 2023 because I didn't want to be written off as a litigator, and I didn't want the competition to benefit from that. So I said, I'm still in the profession. Main zinda hu, chinta mat karo. I'm not leaving this profession so soon. I'll make a lot of lives miserable before I leave the place. So I was positive about that fact. And so 23, I didn't do it. 24 was spent in the designation process. So I said, this year I won't write a book. And the first two books continue to be sold and read heavily. So I said, it's okay. Let the audience ask for the third book. Until then, I won't write. I seriously started writing just a few months ago, despite having commenced the process of the third book. And the regime is 4,000 to 5,000 words a week. That's doable. And that's the only way I get to finish it. Because if I don't, there's this famous law where work expands with time. And with me, every day, if my practice commitments continue to increase, and since they continue to increase, so it's going to get difficult for me to finish the book if I prolong it and I procrastinate it. So the idea is to finish it as quickly as possible. So if you ask me, it should become part of what we call in Hindu philosophy nitya karma. Nitya karma is what you're supposed to do every day, dinacharya. So writing 1,000 words a day or 800 words a day should not be a problem. That should become a part of your habit. At the very least, you're capable of writing 4,000 words a month. That means 1,000 words a week as opposed to 1,000 words a day. That's the easiest thing that you can do. How much is 1,000 words a week? Barely 200, 300 words a day. That's even on the high side. Why is it difficult? So I think that should be possible. If writing is a priority and if sharpening your ability to articulate on paper is a priority, you should be able to do it. Any litigator worth his salt, at the very least, if they're a senior litigator or a fairly seasoned arguing counsel in their mid-30s or early 40s, what do you think the schedule is? 10:30 to 5, they're in court. 5:30 to at least 9:30, they're in the office finishing their briefings for the next day. That means by the time they reach home, it's about 10 o'clock. They do have families to spend time with, so you give an hour to the family. And if you're conscious about your health, you work out for about 45 minutes to an hour. And if you are fairly religious, then you have about 45 minutes to an hour for your prayers. That means by the time you get done with everything, it's almost 12 o'clock. So 12 to 2, you write, get up at again 8 o'clock, rinse, repeat. That's how this works. This is the nature of the profession. If somebody's going to tell you there's going to be a cakewalk or a walk in the park, or you can just get along, of course you can, but then you'll reach only a certain place and thus far and no further. So to answer your question, no, if law school prevents you from writing and you find it draining, I dread to think what you will do once you enter the profession. So give yourself at the very least 5,000 to 6,000 words a month. That's the most reasonable average target that you can set for yourself. Comfortably, you should be able to do it. Which means if you're looking at, let's say, any long form articles between 16,000 to 32,000 words, you should be able to finish an article in a maximum period of a month or 2 months. And most of these writing competitions announce their deadlines well in advance, giving you a 3-month window. In 3 months, you should be able to finish writing an article of 16,000 words to 32,000 words. And that's almost 1/3 of a book. Perfectly doable. What's the problem? You can do it. I don't know if that answers your question, but all I'm trying to say is 5,000 words a month is deadly doable without a problem, without breaking a sweat.
Good evening, sir. My name is Sai Deepak. I wanted to ask one last question. How to read an statute?
अंग्रेजी में या हिंदी में?
दोनों में सर, किसी से भी.
No, see, the point is, think of it as building a logical structure. It's like concentric circles. Kendra Bindu will be the profession, or rather the provision. अगर वो provision समझ में नहीं आता है, then you go to the next level, which is आसपास के जितने provisions है उसको पढ़ेंगे. उसके बावजूद अगर आपको आंसर नहीं मिलता है, you try and look at internal aids such as preamble, so on and so forth. अगर वो समझ में नहीं आता है, then what they call the preparatory materials of a legislation. There's a French word for it. So read that. अगर वो समझ में नहीं आता है, then you go to judgments. अगर आप उल्टा पढ़ेंगे तो आप स्टैट्यूट को कभी नहीं समझेंगे. स्टैट्यूट को समझना है तो आप यहाँ से शुरू कीजिए. Start with this. So Maxwell's principles are fairly clear in this regard. You start with the provision, then you go to internal aids if there is ambiguity, then you go for external aids if there's a problem. And now the Supreme Court says that every provision must be read purposively. Previously, the golden rule was the literal rule. Now they're saying you combine literal rule along with purposive construction, read both together, so that you don't read it literally and end up in logical absurdity, and you combine both common sense and provisions of interpretation together. So broadly that. Which year are you in? Which year are you in, please? The person who asked me this question.
Sir, I'm in second year, sir.
Interpretation कब से है भाई? When do they start teaching you that subject?
Final semester, sir.
अरे रे, बहुत लेट हो गया. सारा कोर्स करने के बाद आपको इंटरप्रिटेशन समझाया जाएगा. What is the point? I don't understand. So I would suggest that you start learning this at least in the 4th semester or the 3rd semester. That blue book of Maxwell should not be read in the final semester, because it's almost as if Sara sab kuch galat kiya to law school mein kya kiya. What is the point? You're learning all the rules at the end of it. So maybe you should have it earlier. Shall we call this a wrap?
Yes, sir. I would like to give a vote of thanks to you for providing this time in your busy schedule. And it has been an enchanting and enlightening experience. And I would like to thank all of the participants and all those who made this possible. Again, a very much thank you, sir. We are quite grateful.
I'll just take 30 seconds, as my friend Anand Ranganathan says, and then I'll wrap this up. It need not be a boring, serious experience. It needs to be a dynamic experience where you come out of law school as one rounded person who is able to do multiple things. And therefore, there is very little time to be wasted. And allow me to say this as candidly as possible. I had a blast of a time in law school. I did everything that I wanted to. I was the perfect company to all my friends who drank. And I made sure that I had fun at their expense. I even said, "Paisa lo, jo karna hai karo, main baith ke tamasha dekhuga." I have no problem whatsoever. So I used to be the World Bank to all the people who drank. And I enjoyed the process completely. I can't think back and say that I was a studious bookworm. I did practically everything, from badminton to running on the 2.2 to being a part of debates or elocution competitions in your spring fest or whatever it is, to organizing stuff, to reading stuff. You can do everything. If you think of law school as your microcosm to the profession, stretch yourself to the limit in terms of things that you can do. You should be able to do multiple things equally well and really well. Once you do that and you enter the profession, you're ready to do multiple things. That's what law school is supposed to prepare you for. And when you read something, there needs to be the dynamic process of reading, which is, once you've consumed it, my apology, think about what you've read. Don't agree and don't accept it. Don't just be a vomiter of information. Be a processor of the data, have your own analysis, have your own outcomes, and explain and critique. Once you do that, reading becomes an absolute dynamic process, and you start enjoying the process. So I'm from C144 JCB Hall, and there is a tree outside my room. So that tree has witnessed a lot of bitching sessions, and the tree has also witnessed a lot of argumentative sessions among friends. And my best teachers were my friends with whom I would discuss the law. Nikhil Ranjan and Ashwini Balayan, both of them. One of them is a partner of ALG India Law Offices, and the other is a counsel in Khaitan. And the three of us would spend our time in that entire corridor, having a lot of fun and also discussing the subject heavily. My routine during examinations was, on the way from my room to the restroom, I would keep asking each of them, bolo, 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 and then my preparation would be done for subjects I'm not interested in. And they would have spent their time reading, and I'd say, okay, take it. And then, of course, I know how to give gyan, so I use that for subjects that I'm not interested in. And for the subjects I was deeply interested in, I don't need a PPT, I don't need a book, I need nothing to start talking about it. So every time you get an opportunity to present your case analysis in classrooms, treat that as an opportunity to showcase the depth, the rigor, and your ability to go extempore. All three are equally important. Do not discount the use and the devastating impact of a powerful memory. Don't discount it. It's going to be an extremely important skill and an asset when you're supposed to hit the ground running and you have to start arguing from the word go without looking at the file. Anything that you read at the dead of the night, if you're woken up and you're asked to start talking about the subject and the file, you should be able to do it. And it is possible. Memory is a muscle. It can be trained. Even if some people are fundamentally gifted, it is not something that you can't acquire. You can. With effort, it's all possible. It's only a question of how much effort you're willing to put in. Okay. Thank you. Do well. Be positive, be optimistic, and be serious. Thank you.
Thank you, sir. We had an enthralling experience.